In this video, we'll continue our discussion of the at-will employment doctrine and exceptions to that doctrine. In the last chapter, we left off talking about the contract exception to at-will employment, either because there's an express contract between the employer and an individual employee that by its express terms limits the how and the why of when you can be fired or have some other adverse employment action taken against you, and likewise the how and the why of when the employee can walk out of their job. And we also talked about an implied contract theory to limit the at-will employment doctrine, where we're looking to the handbooks and the policies of the employer that apply to all employees or that apply maybe to a particular type of employee, but not to one individual person there. And we're looking for violations of the employer's own policies when it comes to taking adverse employment action against an employee, whether that's being fired or maybe not considered for a promotion or something like that. Now we're going to move on in the beginning of this next chapter to talk about the public policy exception to the at-will employment doctrine and talk about a few examples of that. And then ultimately we're going to move into labor law from here after discussing a couple of other things. But here we're just going to focus on a little bit more of these exceptions to the at-will employment doctrine. All right, so chapter covers employment and labor regulations. The difference between employment and labor law is that when we talk about labor law, we're talking about specifically unionized employees, which generally relates to the right of private employees to unionize and how you go about doing that, and what are the rules in that area. So the public policy exception to at-will employment, this is pretty straightforward. We don't want people to have adverse action taken against them in the employment context for reasons that are deemed to violate public policy. And that's usually because it violates some right or obligation that's guaranteed or stated in a statute or regulation or even maybe in the Constitution. And so this comes about basically in two different ways. Either your adverse action is taken against the employee because of you partaking in some right that you have that's guaranteed under the law, or because of something that you're obligated to do under the law, and the employer takes action against you for doing that. So let's look at just some examples. So one thing you might be obligated to do under the law, and it's worth noting that in each state there might be slightly variations as to how this is applied and what all things are considered violations of public policy. So if you're in the situation, it's worth kind of researching, what applies specifically to your state. But we're going to talk about some general reasons that are, generally accepted everywhere. So first, a legal obligation might be that you're called to jury duty, which you don't really have a choice to do, but the employer doesn't like it because you're going to be out for who knows how long. If it's a really serious case, it could be weeks, maybe even months if it's a really serious case. But, they don't want to have to let you be out of work. They want somebody to maybe replace you and not have to bring you back. But that's something that you have a legal obligation to do, and so it would violate public policy for an employer to take adverse action against you for simply obeying the law. And that can come into play when it comes to an employer wanting you to commit some illegal act on the behalf of the employer and you don't want to do it. It would violate public policy to incentivize employers to punish employees for not breaking the law. Or you also have a protection to report criminal activity. Again, we don't want people to be able to be fired from their job or otherwise have adverse action taken against them in the employment context for reporting illegal conduct. And in fact, there's one particular statute that's worth noting, a federal statute that incentivizes the reporting of the misappropriation of federal funds by being a whistleblower on your employer. And if you can help the government recover any money that's been misappropriated from federal dollars, you can actually share in share in some of the money that they're recovered. They'll pay you some of it. And so this happens maybe in a doctor's office or a hospital setting where Medicare and Medicaid funds are being overcharged, or they're reporting x-rays or whatever else that aren't actually being performed. and they're collecting that money wrongfully, someone there with insider information could potentially help the government recover some of that money under that federal statute. And that's just a statute that applies specifically to this broader exception of being a whistleblower and reporting illegal conduct. You also have certain public rights to file reports, such as workers' comp or filing discrimination claims with the EEOC, which we'll talk about more in the next chapter. But we will talk about workers' comp here, so I'll cover it here. So you have a right in every state. Every state has its own similar but separate statutory scheme to where employers of a certain minimum size anyways pay into workers' comp insurance, and so that's how people collect money when they're injured on the job. And it's a no-fault system that makes it easier for people to recover for their on-the-job injuries, and we'll talk more about that later in this chapter. But you have a right under statute to file these reports and to seek compensation. And so that right itself is protected of just reporting. It's not so much about how well you do or how good your case is, but you have a right to attempt to try to get some recompense from that statute that guarantees you that right. And so employers can't take adverse action against an employee for generally filing workers' comp complaints. Even if they don't end up recovering under workers' comp, they still have a protected right to file that report and to attempt to take part in that system. And so that's something important with any reporting statutes where you have a right to report on discrimination or try to file a workers' comp claim. You have a right to public participation in these what are essentially social statutes that have certain public policy behind them, that employers sometimes get into trouble because a claim will be filed for discrimination or workers' comp, and the employee loses the case, and so then after that they take adverse action in retaliation for bringing what they don't think was a good claim. But it's the underlying right to even participate in the system that's actually protected. So you have to make sure not to retaliate against somebody, even if you think maybe they filed a frivolous claim. They still are allowed to participate in that system, even if they lose. Now, this case addresses something in the workers' comp context, which I think is really also alluding to a broader point about lawsuits. What happens here is there's a situation about workers' comp with one employee, but the employee who gets fired is somebody else who wasn't subject to this workers' comp complaint or claim, and he got fired for questioning the decisions of the employer and how they were treating the workers' comp complaint. So he's fired for insubordination for questioning the employer, and he sues, and this is an Iowa state case, so I don't know exactly that there's come out exactly the same way in every single state, but at least in this case, Iowa law and some other states, in this case, find that this employee was not protected under this public policy exception because it wasn't his right that he was exercising. It wasn't his workers' comp claim. It wasn't his on-the-job injury. And the court here in Iowa says the public policy exception applies to the employee who's actually subject to the legal obligation or the legal right, not anybody else who decides to meddle in the situation between the employer and the other employee. So that's something to keep in mind. I don't know how every court in every state would handle every version of this situation, but obviously there's 2 points here really that you have to keep in mind. If you're meddling in somebody else's a possible public policy exception claim, then a court may not protect you. And that's really part of a broader principle called standing, I believe, where generally you don't really have a right to sue and ask the court for protection for things that weren't really directly your injury. So if I can't, that's the way I read this case, sort of. It's, if my friend is injured in a car accident, no matter how much that hurts me in whatever way, emotionally or however, I wasn't the one who suffered the actual injury, and I wasn't the subject of the tort that was committed. So I don't have standing to bring the lawsuit. The friend who was injured has to bring the lawsuit, and if he doesn't want to, then there's no claim to be brought. And here it's like you have a concerned coworker maybe who thinks he needs to stand up for his friend, but it ends up sort of backfiring because of this kind of general standing principle that is being applied specifically here to the at-will, the public policy exception to the at-will doctrine. So it's just, again, something to keep in mind generally, not just in this context, but when you're trying to bring a case for somebody else, there's a good chance you won't have standing, and you could get yourself into some trouble, perhaps. Okay, then the book talks about some contracts in violation of public policy, specifically certain clauses in contracts that might be deemed to violate public policy because basically they're too broad, or they attempt to cover too much. And we've talked about this in earlier chapters, in torts to some extent and in contracts to some extent generally. I'm just going to cover a few here that all kind of get down to the same principle, which is that they might be deemed to be, they might be enforceable, but they might be deemed to be in violation of public policy, and thus a court won't uphold them, or they might invalidate the entire contract depending on the contract and depending on what jurisdiction you're in, because this can vary by state too, exactly how it's applied. But exculpatory agreements or exculpatory clauses are those clauses that attempt to get somebody to agree ahead of time that the other party is not liable for certain things, to exculpate them from certain liability. And as we talked about in torts, generally those can be upheld as long as they're clear as to what rights you're waiving and they're not otherwise deemed unconscionable. And we looked at a case where the rent-to-own place had set up this ridiculous scheme where you could buy a bunch of furniture from them and then default on one payment on one piece of furniture or appliance, and then they had the right to come in and collect everything in your house, basically, that you had ever bought from them under the terms of some loan agreements. And the court said that was unconscionable because we wouldn't expect any reasonable people to say that that's okay, and or things that basically shock the conscience of a reasonable person. So again, they'll be enforceable as long as you state what it is that what rights they're waiving, and especially it's a good idea to just make it clear that they are waiving rights and get them to agree that they understand they're waiving important legal rights. Maybe even have them initial separately on a separate line that says that. Non-compete agreements, we've talked about these before as well. These are agreements where an employee agrees not to compete with the employer after they leave the employer for a certain time. And again, as long as these are reasonable in scope, then they can be enforceable. You just have to keep in mind not to make them either unconscionable or just otherwise so broad as to kind of violate principles of, policies of anti-competition. So I'll just go back over. It comes down to reasonable time, place, and manner restrictions. So for the employee, a lot of jurisdictions have said a couple of years is going to be generally fair, but you can't say in terms of the time, you can't say for the rest of your life you can never work in the fashion industry, for instance, because that means no one will ever be able to benefit from that person's expertise and skill, and they'll never be able to work in the field that they're suited for. So you want it to be reasonable in time, maybe no more than a couple of years. In terms of the place, if you're a business that really only does business in upstate New York, a court's probably not going to enforce it if you say the person cannot work in that field in all of the United States, because it's unreasonable given the competition that the employer is really up against. And then the manner or the scope is how much work are you preventing them from doing. So if it's in the fashion industry, maybe they're a fashion designer, you can keep them for a couple of years working for competitors, designing fashion, but maybe not say that they can't work anywhere in that industry doing something else, doing a type of work that isn't really what you were hired to do for them, and then that isn't in direct competition with whatever it is they're trying to prevent. So it has to be reasonable in balancing the freedom to contract with the policy, that of refraining from things that are designed to be completely anti-competitive in the otherwise free marketplace. Anti-rating covenants, this has to do with agreeing to not trying to recruit after you leave an employer, not trying to recruit some of their employees, not trying to poach them. Again, that basically comes down to reasonable restrictions. You can have them, but you can't say nobody from here can ever work for you as long as you live. This is a case, I'm not going to go through the facts here, but I'll put it up here. You can pause and read to see an example of how this plays out, specifically anti-rating agreements. Okay, we're going to leave it there. I'm not going to go into substance abuse right here. We'll just stick to the at-will employment exceptions and come back with the rest of the chapter in subsequent videos.